And it is my pleasure to welcome you to our webinar, which is organized in the context of the TRIAL project. TRIAL is a project that is dedicated to the rule of law in the European Union. The acronym TRIAL stands from Trust, Independence, Impartiality, and Accountability of Legal Practitioners, safeguarding the rule of law under the EU Charter. TRIAL is a project that is funded by the European Commission under the Justice Programme, and it is led by the Center for Judicial Cooperation together with a consortium of 12 other partners. The project has its own webpage within the Center for Judicial Cooperation website. I've already written in the chat section the link where you can find the website. And there you can find the complete list of partners involved, which comprise universities, research institutes, judicial schools, a bar national association, ranging from a total of 10 EU countries. You'll find more information on the activities that we're going to carry out throughout this year as well as next year within the framework of the TRIAL project in a presentation video that is done by Professor Gabor Halmai, who is the scientific coordinator of the TRIAL project. There you will also find a database developed within the TRIAL project, which includes both European and domestic case law on mutual trust, judicial independence, impartiality, accountability, and rule of law. For the moment, the database comprises around 60 European and national case law, but we intend to develop the database so that by the end of the TRIAL project next year, we will have more than 200 cases. You will also already find in the chat section the link to the database. And I invite you to search and have a reading of the cases that are already present there. Now, turning to today's webinar, this is part of a series of at least 3 webinars where we have invited scholars and practitioners to discuss European and domestic case law on the 5 themes that we cover within the framework of the TRIAL project. And let me repeat them again. That is mutual trust, rule of law, judicial independence, impartiality, and accountability. On the TRIAL website, you can already find the first webinar that took place on the 28th of January. And we recorded that. So if you're interested on the rule of law and mutual trust, please have a look at this webinar. In today's webinar, we will focus on a different question, and that is whether there is a common standard on judicial independence and impartiality for judges and arbitrators under European law. We will discuss this theme with 2 distinguished speakers, lecturer Karolina Podstawa from the University of Maastricht and Professor Barbara Warbas from the Hague University of Applied Science. Before giving them the floor, I would like to emphasize the specificity of the TRIAL webinars, which is that we want to go beyond the case law of the European Court of Justice, and we also want to follow up how its standards on judicial independence, impartiality, and accountability are followed by domestic courts, and also whether these standards apply to other legal professions, such as prosecutors, lawyers, or arbitrators, as we will discuss in today's webinar. Let me recall that this webinar is recorded because it will become part of the forthcoming TRIAL online training platform that will be made available within the website. There will be an opportunity to address questions either at the end of the webinar when we will turn on the camera for all attendees, or if you prefer, you can also write down your questions in the chat section. So without further ado, I'd like to give the floor first to our first speaker, lecturer Karolina Podstawa, who is going to introduce the standards on judicial independence, impartiality, and accountability as resulting from the most recent case law of the European Court of Justice. So Karolina, the floor is yours.
Madalena, thank you so much. Welcome everybody. It is my pleasure to speak here during this TRIAL webinar number 2. Allow me a moment just to share with you my PowerPoint presentation so that we are all in a good shape. All right there, I think. It says that the presentation failed to start, so please allow me for a moment. There's always a little moment of a technical glitch. Here we go. Okay, good. Yes, so I represent here the University of Maastricht, which is one of the partners of the TRIIAL project. And in the TRIIAL project, we actually do focus, aside from on creating of this e-learning platform that Madalena mentioned, but we do focus, in fact, on two aspects of judicial independence, namely the appointments of judges and the role of the self-governing bodies of the judiciary. So I call them in this presentation self-governing bodies. But in today's webinar, we focus on something different. And in fact, we have conceived my presentation as more of a kickoff of a discussion, something that Barbara will react to, with the underlying question as to whether we do have sufficient tools to conceive of a common standard of judicial independence for the judiciary and for the arbitrators, and perhaps also for the other entities that are engaged in the administration of justice in variety of settings. So let me start off with setting a little bit of a context for you. I mean, I speak about the TRIIAL context because this is where we, this is the background or the setting within which our webinars take place. But of course, this is the context of the rule of law and judicial independence struggles in the past years, and I suppose future years as well. And this is the context of European Union and the European continent in broader context, sliding away from the democratic values. So this is something that in academic literature we refer to as anti-constitutional populist backsliding. Then in the Polish context, Professor Sadurski has been referring to it. And that is a bad thing, of course, but it's also a good thing in the sense that it actually brings to the table the topic of judicial independence, impartiality, and accountability to the scale unseen before. And this is thanks to this phenomenon. We actually are discussing this issue today online or at the Zoom virtual table. So somehow I call Polish perpetrators also the people that should be merited with the task or for the bringing this whole topic to our attention. But of course, this in the case law of the European courts, we see also the Hungarian, Romanian, Spanish, Italian settings, or the Italian judiciary and the judicial systems under scrutiny. And what is interesting is that all judges contribute to this discussion in the form of the procedural judicial dialogue, which perhaps could be considered as a sort of chief tool to the devising of a recipe for the common European Union standard of judicial independence and impartiality. So now, for the purpose of this presentation, let me just narrow down a little bit all the considerations, so the broad field that we usually analyze in the context of the judicial independence and impartiality, by posing two essential questions. The first question refers to the ripeness, perhaps for the lack of a better word, of this standard. In other words, I mean, when we do discuss the case law of the European courts and the follow-up cases of the national courts, and I will refer here to the courts of the Polish state, then the first question that emerges, of course, is really whether we do have sufficient information of how this standard has been conceived of, and whether it can be actually applied in a straightforward and perhaps not prone to manipulation manner. And as we know here, it is the strategy of the European courts to give the framework guidelines, the general guidelines as to how to apply the standard of protection of certain fundamental or human rights. Whereas what the national judges tend to look for is the strict guidance or the strict tests that they can apply in their national setting, such that that will leave no doubt as to whether the specific fundamental or human right is being observed in this context. So obviously, when I speak about fundamental human rights, I'm referring to Article 47 of the Charter of Fundamental Rights of the European Union or Article 6 of the European Convention of Human Rights. This emergent standard is based on the existing work that's been done on the international level in the form of a series of international legal instruments that comprise of the elements of the standard that's been later on endorsed by the European courts. And of course, it is very much rooted in the constitutional traditions of the member states of the European Union and the constitutional settings of the states parties to the European Convention of Human Rights. Now, what the second question that sort of emerges against the framework or the background that I have already sketched for you is that of the applicability of the standard ratione persone, in fact. So the question really is, who do we apply the standard to? In narrow sense, so in other words, when we are speaking about judges, do we actually include all the judges in the standard or not? And I will come back to that question at the end of this presentation. And in the broader sense, I mean, do we actually include in the standards, in the application of the standards, all the individuals involved in the administration of justice, be it in civil or criminal matters? So these are the two major questions that I would like to address in this presentation, or perhaps leave to your consideration whilst outlining the context of the judicial independence and impartiality in the European Union. So let me move on then. As I mentioned, the standard as we know it now, it is built on existing standards that's been out there for many, many years. And perhaps I should just mention some of them, meaning the 2007 Bangalore Principles on Judicial Contact, the Venice Commission standards, or even the European Convention of Human Rights. However, this more recent agility and the activity on the part of the European Court focuses on the relationships on the Article 6, but in particular in the European Union context, Article 2 of the Treaty of the European Union, 19, and Article 47 of the Charter of Fundamental Rights. What we see now is that we do have a certain framework understanding of what the standard entails, but perhaps we do not really know how to apply the tools that have been put forward to us. Or maybe this is different in your understanding. The main areas that have been identified, or the ones that we've been working with in TRIIAL project, are those of the judicial appointments and the position of a judge as of this irremovable figure. And self-government of judges, finally, disciplinary proceedings and freedom of expression of judges. These are the four areas that have been that have seen an increased judicial activity on the part or within the European context. Today, we will focus mostly on the judicial appointments and irremovability, and the standard as it is can be applied to the context of the arbitrators, or raising the question whether it can be applied to the arbitrators, and also self-government of judges, so the judicial councils. However, disciplinary proceedings and freedom of expression will be something that will be discussed in a different webinar of TRIIAL. It will be, however, addressed to a certain extent from the perspective of the arbitrators. And so, what is the emergent standard? So the standard that's been emerging against this background of the struggle, really, of judges and I suppose the democracy-abiding entities within the different member states, in particular the Polish one, against this democratic backsliding. So, in fact, the standard, as we see now, I mean, can be traced back to the case of Commission versus Poland. So this is an infringement proceedings case concerning the independence of the Supreme Court, where the court actually summarizes the findings concerning the standards of judicial independence and impartiality that should be applicable within the realm or within the areas covered by the European Union law. And this standard actually emerges from the tradition of the Court of Justice of the defining of what is this court and tribunal under Article 267 of the Treaty of the Functioning of the European Union. So what it means for the entity, or what it means from the perspective of the Court of Justice of the European Union to accept a preliminary reference from a body that would fill or fulfill the requirements of being a court of a tribunal on one hand, and secondly, this is a standard that actually does emerge on the basis of the Article 19 and 47, Article 19 of the treaty and 47 of the Charter of Fundamental Rights. So we know that a judge who is independent in this context does exercise his functions autonomously. So he's not supposed to be subject to any hierarchical constraints. And in doing so, he's supposed to display, in line with the LM case, a lack of any interests other than the application of the rule of law. And those two elements must be guaranteed, in part, of course, because of course there are certain elements that cannot be guaranteed in this way, by the rules concerning the appointment, length of service, and grounds of abstention, rejection, and dismissal of the members of the body that actually appoints the judges, but also the judges themselves. And this is something that goes back, in fact, in the case law of the court to the memorable Wilson case that was decided on the basis of Article 267 mostly. So this is our starting point. That starting point continues with the elements that focus on the irremovability of judges from the office. So this is the second or the second set of the elements. And finally, that brings us, so that standard that's been summarized in the case concerning the independence of the Supreme Court in the Polish context, that actually brings us over to the concept of the appointments and the self-government of judges in the context of the subsequent case concerning the Council of the Judiciary, again, the Polish case, that focuses on the description of the subjective element of what it means for the judiciary to be independent and impartial, by first establishing the links between Article 1947 and 2 of the Treaty of the European Union. And in fact, what is most important in the context of establishing the link between those three elements is in fact that the fact that the member states are actually required to provide remedies that are supposed to ensure effective legal protection in line with Article 19 of the Treaty of the European Union. But that principle of effective legal protection is considered to be a general principle of EU law that is subsequently enshrined in Article 47 of the Charter. In other words, there is a link, albeit a little bit problematic and a little bit requiring more elaboration, perhaps also from the court itself, between Article 47 of the Charter and Article 19 of the treaties, explaining also the applicability of the Charter in this context. Now, moving that part aside and focusing on the subjective element of the judicial independence and impartiality that emerges from the case concerning the Council of the Judiciary in Poland, we are looking at the test that focuses on the three elements referring to the formulation of the court and the appointment of the judges that are capable of giving rise to legitimate doubts in the minds of subjects of law, in terms of the imperviousness of the court to external factors. So, in fact, the ability to force court's hand one or the other way, and the neutrality of the court or impartiality with respect to the interests of it. So this is something that the Court of Justice of the European Union has put forward as a sort of general standard. The problem that emerges here is that the court focuses in its analysis and in the summary of how to approach the issues of independence and impartiality on two elements: on the evaluation of the legislation, but above all on the evaluation of the facts of a given case that needs to be applied in light of the standard of that I have presented to you, or the elements of the standard that I have presented to you, to a given fact of the case. And that can be quite a problematic activity. And in fact, if you look at the more specific context of the application of the framework decision on the European arrest warrant, the court actually echoes again the need to introduce this subjective evaluation of the situation in a given state that would be a receiving state of a person subject to the European arrest warrant. And the court emphasizes that the fact that the state could have been or was subject to the scrutiny on the part of the Court of Justice of the European Union is not sufficient to consider that state is not adhering to the principles of rule of law, in as much as the principle of judicial independence and impartiality is concerned. And this is an important element, an important consideration that I think is also extremely applicable to the discussion in our today's webinar, because, as you can see, even if the courts try to obtain a more clear understanding of what the standard entails from the Court of Justice of the European Union, they actually face with the answer, which is very much hands-off. This answer that is extremely hands-off is given both to courts within the countries such as Poland, Hungary, or Slovenia, so the ones that I've mentioned that have been subject to scrutiny of the Court of Justice of the European Union, but also to other countries such as the Netherlands, which in fact was the case in this example that I am quoting for you. Perhaps at this stage, it would be interesting to actually have a look at what it is that the European Court of Human Rights delivers to us in terms of the guidance as to how to apply the standard of judicial independence and impartiality. And in fact, the European Court of Human Rights focuses on Article 6 notion of the tribunal established by law. So in fact, we do have a right to the scrutiny of a tribunal established by law. And in an Icelandic case, whose name I cannot pronounce, so I'm not going to even attempt, that was decided on the 1st December 2020, so it is as fresh as it gets. We do see the development of a new test, or maybe in fact the transformation of the old test into dressing it up in new clothes. And this is basically a test that actually tells us about what happens, or when is it that under the convention we should consider it a violation of Article 6 in terms of the judicial independence and impartiality. And what is interesting there is that the three elements of the test consist of two elements that are the absolutely essential parts, or the essential conditions that need to be met by the court. Or by the evaluation of the court, whereas the first element is not considered to be a sine qua non. In other words, we start off with our understanding or with the analysis from the manifest breach of domestic law. In other words, we're looking at whether a given situation or the appointment of a judge, as it was the case of our Mr. Astridson, okay, I did attempt that, whether the appointment of a judge actually was conducted in a manifest breach of domestic law. And in the case at hand, that was the case. And in fact, the Supreme Court of Iceland has decided to this effect. But the court, the European Court of Human Rights, I think, is really trying to adjudicate the cases that we see in light of the spirit of the time. So they immediately state that perhaps even if the national courts did not decide that there was a manifest breach of domestic law, that condition shouldn't be considered as a sine qua non element of the test. In other words, even if this element is not fulfilled, which is quite an extraordinary statement to make by the European Court of Human Rights, one should proceed to the examining of the further two elements of the test that's been devised in this case. So in other words, taking the Polish context again as a reference, we know that our constitutional court, for instance, would not consider the circumstances of the Polish cases to be a manifest breach of domestic law, but that may not be the case when evaluated from the external perspective. That means that one should proceed to the evaluation of the two other elements of the test, namely, whether the breach of the law has been conducted in the or against the object and the purpose of the requirement of the tribunal established by law. In that part of the test, the European Court of Human Rights emphasizes that what is really important is that the fundamentals underlying the conditions essential for the tribunal to be established by law under the European Convention standards have been breached. So if those circumstances amount, or if the fundamentals have not been maintained, then this breach will be declared. It is an important element, again, that element of the test, because it really points to the fact that there is a subjective evaluation entailed as to whether we are looking really at the fundamentals or not. What are the fundamentals that are in fact focusing on the preservation of the rule of law and the separation of powers? I mean, we all assume that these are the constitutional guarantees. But when is it that these finish? So how do we delineate one of the other? Finally, or the final element of that test is that there should have been a review by a domestic court of the case in question, and that review of a domestic court should adhere to the standards of the convention. Again, as in the case of the Court of Justice of the European Union, that standard that is being contributed to the discussion that we're actually having now is a very abstract one, and we are awaiting for the court's pronouncements on, again, 2 or 3, in fact, even Polish cases. So Broda and Bojara versus Poland on the one hand, but also Exeroflors versus Poland. And that second case is an interesting one because it actually does focus on the fundamentals of what it means for the tribunal to be established by law, and the breach of the domestic law. So those two first elements of the test will need to be addressed by the European Court of Human Rights in this case. But above all, that case considers the appointments of judges to the Constitutional Court of Poland. And that actually is a nice transition to the final points that I'd like to make during this today's presentation, namely, actually to open up a little bit of the questions to you and to Barbara for the future consideration. because the real question is really, who do we apply those standards to? In particular, in the context such as the Polish ones, but also going beyond the traditional system or the limited system of the administration of justice in civil and criminal cases. In particular, of course, whether we do apply this standard to judges, so entities that are appointed to the constitutional courts. And in fact, here I would like to bring your attention to the fact that there is a case pending concerning the Romanian Constitutional Court, or the Court of Cassation. And perhaps I will ask Madalina to speak about it later in our Q&A as to whether the standards that I have referred to do apply to the judges of that court. And what is, of course, in the settings of the Constitutional Court judges that, according to their national rules, are not considered to be judges. So what is their standard? What would be the standard of their independence in the light of what is emerging on the European Union level? And how would we consider the breach of the standard in the light of the test of the European Court of Human Rights? The second open question that is still out there, and I mean, the European Court of European Court of Justice so far has been extremely active in the area of the European arrest warrant. So we do see this willingness on the part of the CJEU to include in the concept of the judicial authorities under the European arrest warrant framework decisions as many bodies as possible. So all the bodies, in fact, involved in the administration of criminal justice. And I think that this is also an interesting topic, because that refers us to the jurisdictions where perhaps not only the judges are actually taking decisions that concern individuals that are subject to the European arrest warrant decisions. Okay. And then finally, to bring our discussion back home, in fact, to Barbara, I would like to perhaps outline the application of those of the standard to other bodies in the context of alternative dispute resolution, including arbitration, by asking a very simple question as to whether we can draw analogies in terms of what is the position of judges, what is the position of the councils of the judiciary, what is the position of the disciplinary proceedings or the freedom of expression of the judges, and whether that standard can inform the understanding of who the arbitrators are and how they are being and how their position is being actually framed according to the applicable rules. What is the role of arbitral institutions in this case, and perhaps beyond our discussion today, but also what would be their accountability and liability in the context of disciplinary proceedings. In other words, questions for Barbara to address, I suppose, is when is it that in fact judges do review the standards of independence and arbitrarity and impartiality of arbitrators? And what does this standard mean in that context? And how can we draw the analogies for the arbitral institutions? And in fact, to what extent what I have said actually matters in that particular area. Thank you so much for your attention. And Barbara, I stop here and hand over to you.
Thank you very much, Carolina. I will also now take hopefully 1 minute to share my screen with you. Today basically what we would like to do with Carolina is to try to answer the question whether there is a common standard of independence and impartiality in such two distinct systems as ordinary justice system and arbitration. And I will focus in my presentation on the judicial review of the standard of independence and impartiality in arbitration based on the case Mutu and Pechstein versus Switzerland. I would like to stress that it's a landmark decision in sports arbitration, and sports arbitration is as such a very specific field. But I chose this case because it has direct linkages with the discussion on the standard of independence and impartiality of arbitration or of arbitrators, especially in the context of the European Convention of Human Rights. So I will start today by giving you a very short summary, hopefully this will be short, of facts of the case, Mutu and Pechstein versus Switzerland. This is quite important for us also to understand to what extent judges in fact reflect on the standard of impartiality of arbitrators. And I will also focus on the question that was the core question in the decision of the European Court of Human Rights, namely whether the Court of Arbitration for Sport is an independent and impartial tribunal under Article 6 of the European Convention of Human Rights. And I will also make implications of the case for the trial training, and then we will hopefully have a Q&A session where also we can answer the question on whether there is a common standard of independence and impartiality between judges and arbitrators. When it comes to the Mutu case, Mr. Adrian Mutu was a professional football player who signed an employment contract with Chelsea club. And shortly after that, he tested positive, and shortly after his transfer, he tested positive for cocaine during a routine drug test. Chelsea terminated his contract with immediate effect. And afterwards, both Chelsea and Mr. Mutu initiated the proceedings before the Football Association Premier League Appeals Committee that was to determine whether Mr. Mutu in fact was in breach of his employment contract without just cause. And that was important for the award of compensation to Chelsea. The appeals committee determined that such a breach had occurred, and of course, Mr. Mutu appealed this decision to the Court of Arbitration for Sport, CAS. The arbitration panel upheld the appeals committee decision regarding the breach of contract in its first award. Subsequently, Chelsea requested that the FIFA Dispute Resolution Chamber awards compensation from Mr. Mutu. And there was a procedural question of the jurisdiction, which decision was appealed by Chelsea to CAS that agreed with Chelsea regarding who had jurisdiction to decide on the compensation in its second award. Chelsea, as a result of this, was also awarded of this decision, was awarded 17 million euro from Mr. Mutu, who again appealed this decision to CAS. He also, and that's where the discussion also becomes interesting, is that Mr. Mutu challenged the German lawyer who presided over the arbitration panel in the first arbitration award before the International Council of Arbitration for Sport. The challenge was dismissed, and the third panel award was issued that dismissed Mr. Mutu appeal in whole, and as a result, Mr. Mutu was to pay the compensation to Chelsea. That's important because following the further route, Mr. Mutu decided to appeal or start a proceeding for the annulment of the award before the Swiss Federal Tribunal that had jurisdiction to hear these type of challenges. And the main claim of Mr. Mutu was that there was a concern regarding independence of CAS arbitrators. He had challenged two arbitrators who sat on the panel that issued the third award, and the challenge was based on anonymous emails sent to Mr. Mutu's counsel that stated that the law firm where the arbitrator in question worked represented the interest of a Russian businessman who actually controlled Chelsea, and that was not disclosed to the parties. When it comes to the second challenge regarding the second arbitrator, Mr. Mutu stated that the arbitrator in question actually presided over the panel that issued the first award in the whole saga that was issued in favor of Chelsea. The Swiss Federal Tribunal dismissed this case and didn't find these claims grounded. It actually observed that the arbitrator regarding the first claim filed a statement of independence in response to the allegation, and Mr. Mutu did not engage with such a statement. And regarding the second claim, the Swiss Federal Tribunal did not find the ground substantiated regarding the anonymous email and also the fact that there were two awards issued by the same arbitrators because the court also stated that these awards concerned two distinct issues, and that the behavior of the arbitrator did not cast doubt on his independence. The case was dismissed, and Mr. Mutu brought this case before the European Court of Human Rights. This is where we also start our second case that was joined with Mr. Mutu before the European Court of Human Rights, namely Ms. Pechstein case, that also concerned Court of Arbitration for Sport. What was interesting in Ms. Pechstein case is that Ms. Pechstein was a German national who was a professional speed skater, and she was affiliated with the German Sports Federation, which was part of the International Skating Union, the so-called ISU. In February 2009, Ms. Pechstein took part in ISU's championships in Norway, where her blood levels were controlled a few times and they were said to be irregular. As a result, Ms. Pechstein took part in disciplinary proceedings against her as an athlete, following which she was suspended for 2 years. Following these decisions, she initiated a case before the Court of Arbitration for Sport. The Court of Arbitration for Sport started the proceedings. The CAS announced the composition of the arbitration panel, and there were no complaints. The hearings were held in private, although Ms. Pechstein actually requested for a public hearing. And as a result, the Court of Arbitration for Sport upheld the ban on Ms. Pechstein in its award in November 2009. And following the procedural path, also similar to Mr. Mutu, Ms. Pechstein started a proceeding in the Swiss Federal Court for the annulment of the award, and she raised more systematic issues and allegations regarding the composition of the Court of Arbitration for Sport. There were three main grounds: that the CAS was not an independent and impartial tribunal regarding the process for the appointment of arbitrators. And for those who are not necessarily familiar with the CAS arbitration, the CAS keeps a roster of arbitrators from which the disputants can choose their arbitrators. But so it's a closed list, but it's a rather extensive list that comprises currently around 300 arbitrators. The second ground was that the CAS president was not impartial because he was known for taking a so-called hard line on doping. And the third claim was that CAS Secretary General had changed the award a posteriori. This case was also dismissed, and the court basically stated that those claims of Ms. Pechstein were unfounded, vague, too general, and speculative. The case was dismissed, and Ms. Pechstein initiated also court proceedings in her home country, Germany. That was quite interesting because these proceedings focused mostly on the question to what extent sports arbitration is a consensual arbitration. As a result of these proceedings, also Ms. Pechstein brought the case before the European Court of Human Rights, and this is where the two cases were also joined. And the European Court of Human Rights was basically faced with three issues, one of which is the one on independence and impartiality of CAS. It's quite important for us today because the court first had to, of course, reflect on the fact whether the Court of Arbitration for Sport can be regarded as a court and tribunal established by law. And the answer to this was affirmative. The European Court of Human Rights stated that the CAS issues judgments that are real judgments similar to those of a state court, and that the Article 6 of the European Court of Human Rights is also applicable to the guarantees that the CAS is supposed to offer to the parties. The court also reflected on what in fact are the what in fact is the standard of independence and impartiality. And of course, here we can find already a few parallels. And of course, this is in relation to the court and tribunals. So these are the standards, I would say, regarding which need to be taken into account when we speak about independent and impartial tribunal under Article 6 of European Court of Human Rights, namely the manner of the appointment of the members of the tribunal and the term of office, the existence of guarantees outside pressure, and the question whether the body presents an appearance of independence. And when it comes to impartiality, the court, of course, mentioned the denotation that there should be the absence of prejudice or bias. When it comes to Mr. Mutu's case, the European Court of Human Rights dismissed the arguments of Mr. Mutu and agreed with the Swiss Federal Tribunal, saying that the two cases that in fact were decided by the same arbitrators concerned two distinct legal issues, and there was no appearance of bias in the behavior of the arbitrator. And also regarding the anonymous email on the ground against another arbitrator that Mr. Mutu raised, this was also found unproven. As such, the court stated that there was no violation of Article 6.1 of the European Convention of Human Rights. When it comes to Ms. Pechstein's case, the situation was similar to the extent that the court did not find that there was the question of independence and impartiality of the CAS arbitrator, that the claim could prove that the court was not impartial or independent. And again, the court stated that the CAS, the arguments that Ms. Pechstein raised, first of all, were not raised directly in the CAS arbitration proceedings, but they were also raised in a way that was vague and hypothetical. What is quite interesting is that the courts mentioned that the fact that the CAS is funded by international sports organizations, which also was a claim of Ms. Pechstein against independence and impartiality of CAS, was not sufficient to prove that CAS was not necessarily independent and impartial per se. And the court drew a parallel with state courts here, which are also financed by state, but it does not necessarily mean the lack of independence. Consequently, the court stated that there was no violation of Article 6 of the European Convention of Human Rights on the ground of lack of independence and impartiality. Now, this case is quite specific because it concerns the Court of Arbitration for Sport. So the sports arbitration that is rather specific, and the trial training that we are focusing on concerns many different types of arbitrations, including consumer arbitration, commercial arbitration, and so on and so forth. before. But what is important for us to derive from this case is, first of all, when are judges in fact faced with the judicial review of the standard of independence and impartiality of arbitrators that usually are considered very distinct from ordinary justice system? The second question is, what is the standard of independence and impartiality of arbitration? And how is the whole system organized? Can we see any institutions that, for example, could mimic the role of the councils for judiciary in arbitration? Are there any other guardians of independence of arbitrators? Another question is, what in fact is the status of arbitrators vis-a-vis the parties, and whether it affects, and if so, to what extent it affects our discussion on the standard of independence and impartiality. So I will very briefly go through these questions also because they refer to the questions raised by Carolina. Afterwards, we hopefully can also have a discussion, more in-depth discussion around these questions and beyond. So one would think that the arbitration was developed as a completely separate system of administration of justice as opposed to ordinary system of justice. In fact, judges are faced with judicial review of the standard of independence and impartiality of arbitrators, as we can, of course, as the case that I referred to demonstrate. So there are three categories of situations where the judges will be faced with the judicial review of the standard of independence and impartiality of arbitrators. First, annulment proceedings. As we can see both from the case, both Mr. Mutu and Pechstein initiated annulment proceedings in state courts, and this is where national judges will be assessing under national civil procedural codes and civil rules and the New York Convention for the Recognition and Enforcement of Foreign Arbitral Awards, the standard of independence and impartiality. In fact, the right to a fair trial and the standard of independence and impartiality of arbitrators is one of the very few grounds that create the so-called window and the corridor between arbitration and state courts, because state courts and judges cannot review arbitral awards on their merits, but they can definitely look into procedural standards and guarantees. The second category of cases, which is quite related, of course, to the first, concerns the observance of the right to a fair trial in mandatory arbitration, especially such as sports arbitration. It's, of course, controversial to what extent sports arbitration is voluntary or mandatory, but if we follow the distinction also of the European Court of Human Rights, in mandatory arbitration that is imposed by law, the standards of independence and impartiality of arbitrators under Article 6 of European Court of Human Rights needs to be observed. And the third category of cases concerns civil liability of arbitrators and arbitral institutions. These are cases that are brought directly by the parties to national courts against arbitrators and arbitral institutions for their potential misconduct. So what would the judges look into while deciding on the standard of independence and impartiality, or whether deciding whether there was a potential whether these guarantees were not met? It's quite interesting. I took, here is the quotation of the Swiss Federal Tribunal's judgment in Mr. Mutu's case. And I will read to you one passage which states that in order to determine whether an arbitral tribunal presents such guarantees of independence and impartiality, reference must be made to constitutional principles developed with regard to national courts. However, the specificities of arbitration, in particular those of international arbitration, must be taken into account when examining the circumstances of a given case. And I think that this passage perfectly summarizes the actual way in which judges approach independence and impartiality of arbitrators. Judges cannot ignore constitutional principles and national case law and European law case, case law. That being said, it's always within this disclaimer. the specificity of arbitration always needs to be taken into account. So let me tell you a little bit more about the specificity of arbitration. If you look at most arbitration rules, and now I'm zooming out from sports arbitration, the arbitration is a very specific field because, of course, the parties waive their right to go to a court if they decide to go to arbitration in voluntary arbitration. So the standard of independence and impartiality will always need to be assessed by parties to a dispute first. So in most, at least commercial rules of arbitration, you would see that there is a duty of to disclose potential circumstances, which might be of such a nature as to call into question the arbitrator's independence in the eyes of the parties. That being said, the duty of disclose does not necessarily mean, of course, that there are different categories of cases that may have different consequences for the standard of independence and impartiality. And in severe cases of conflict of interest, the parties will always need to agree on those circumstances and potential bias, and they would still be able to go ahead with the arbitrator in question. So the fact that there is a bias, it's not necessarily per se excluding the arbitrator from acting in a specific case. So how is the standard regulated from the arbitration point of view? It's always regulated in arbitration rules, procedural rules that apply to arbitration, and in soft law instruments. For example, in the IBA guidelines on conflict of interest, the guidelines of the International Bar Association that were also referred to by Mr. Mutu. So the judges will also look into the situations through the so-called lists that are included in the guidelines. And there are 4 different lists that create some sort of guidance for arbitrators, the parties, and then of course also judges on how to assess the standard of independence and impartiality. In the interest of time, I will skip the explanation of those lists, but I think what we can summarize from this discussion is that from the perspective of arbitration, there is always a duty to disclose, which matters, of course, when in the assessment of the standard of independence and impartiality, because if the circumstance is disclosed and then the parties agree on this, or at least do not oppose, there is basically not a concern. That being said, it's also important to look what type of arbitration it is, whether the parties in fact consented to arbitration. And as we can see in Mr. Mutu and Pechstein case versus Switzerland, the consent is also quite important because it determines whether in sports, in this case, the problem was whether sports arbitration was in fact voluntary arbitration and whether the parties had opportunity to also reflect on the standard of independence and impartiality. I also put here a quotation, which I think of Mr. Martin Hunter, who is a professor and a prominent arbitrator, who in fact quite nicely summarized how to approach standard of independence and impartiality from the arbitration point of view. When I'm representing a client in arbitration, what I'm really looking for in a party-nominated arbitrator is someone with the maximum predisposition towards my client, but with the minimum appearance of bias. And I think it's always, it summarizes in a interesting way that there is always the need to weigh to what extent there is a bias and to what extent there is a consent to this bias. When it comes to another question, and I'm leading towards the end because I know that we are running probably out of time, what are the other actors in the arbitration system that safeguard the independence of arbitrators? And in the situation of institutional arbitration, such as the sports arbitration that I mentioned. We have, of course, the Court of Arbitration for Sport, and we also have the International Council of Arbitration for Sport, which has some parallels to the role of the councils for judiciary in ordinary justice systems, because the ICAS actually keeps the roster of arbitrators. It also, its role is to maintain and safeguard the independence of CAS as such. It is a controversial institution, but it exists. And I would say when we are looking for parallels, I would say that it's the first type of actor that actually we should scrutinize. In the situation of commercial arbitration, we also have a number of arbitral institutions that do not have a fundamental role in safeguarding independence and impartiality in a more systematic way. So maybe the external independence. However, they do administer the proceedings, and they do include different safeguards through which the independence and impartiality must be guaranteed. So what in particular are those instruments? Each institution, of course, in its own rules would have mentioning of the possibility of replacements of arbitrators on institutions' own initiative, or at least challenges. The challenges of arbitrators are regulated in institutional rules, and some institutions would have also regulations that would allow institutions to replace arbitrators. These are rare provisions, but they do exist. Each institution would also have a statement of arbitrators' independence and impartiality, that and sometimes also of availability, that arbitrators would need to sign before they actually agree to serve in the case. And some institutions would also have codes of ethics, which are, of course, hard to enforce because they are soft instruments. But sometimes they also have a provisions like in the Chamber of Arbitration in Milan, where they give some extra quasi-judicial powers to arbitral institutions. So just to finalize, I would also like to stress that there is a fragmentation in the approaches to the standard of independence and impartiality in the judicial review. It depends, of course, on the level of courts. It depends also on how the courts treat and judges treat arbitrators. And some arbitrators are treated as quasi-judges, while in some jurisdictions, for example, in the United States, and in other jurisdictions, like in most European jurisdictions, arbitrators would be treated as service providers. And this largely also determines how judges interpret the standard of independence and impartiality, and based on which arguments. So I think I would like to finish here and open the floor for the discussion. So I maybe give the floor also to Madalina, and thank you very much.
Thank you very much, Barbara and Carolina, for the rich presentation, but also for making light in such a rich and difficult topic as independence of arbitrators and judges. As you can already see, all the participants have been enabled or turned on video. So if you want to raise question, you can either raise your hand, or you can simply turn on your video and address live your question, or of course just write down. I see that there's already a raised hand. Julia from Julia Lafranc. Would you like to mention your question, and also for whom your question is addressed? Julia.
Thank you very much. Thank you very much for both the speakers. Actually, it is a rather additional question to both of them. I have had the honor to be a judge both at the European Court of Human Rights, and I'm very thankful for mentioning both the recent Icelandic case, as well as, of course, the case about the arbitration court. And I've also been a judge at the Supreme Court. Currently, I am acting as a director of program at European Academy of Law. I would like to perhaps just first mention that also as a former president of Consultative Council of European Judges, in addition to these Bangalore principles and obviously the European Convention on Human Rights and the Charter, of course, there are opinions provided by the Consultative Council of European Judges. And I would like to draw your attention in particular to the opinion number 1, but also to the opinion number 5, which brings me to my question. I must say that the independence of judiciary is should be as natural as the air we breathe. It is also very much a state of mind, a question of mentality and training, but also, of course, as you correctly mentioned, the appointment of judges. And it should not be seen as a privilege of judges, because a topic it itself is not very easy sometimes to understand, but it is a privilege for those who are seeking justice. And my question would be, in that respect, in addition to what we have heard about national courts and constitutional courts, as well as arbitration courts, what would you think about these principles that you have introduced us today, and you will continue in these very interesting webinars extensively to introduce in the following sessions, such as freedom of expression and other aspects, disciplinary aspects? How do these principles apply also to the international courts and to the European courts? Because this opinion number 5, namely also of the Consultative Council of European Judges, touched upon the appointment of judges to the European Court of Human Rights. Thank you very much.
Thank you very much, Julia. I don't see any other hands raised, so maybe I'll just give the floor first to Carolina and then to Barbara to address the question. Carolina?
Thank you so much, Julia. In fact, indeed, this is actually one of the, can you hear me? I don't even know. Yeah, it's all good. Okay, it's in fact one of the things that we have considered a little bit within the TRIIAL project, as in what is it, what are the principles that apply to the international judges, so European Union and European judges in terms of the appointment, and whether we should actually include them also within the realm of the TRIIAL project, you know. And we decided a little bit to address the general principles, of course, but not to focus on the European Union ones and the European ones in general either. Having stated this, as you said, the judicial independence is not a privilege of judges, it's a privilege of people, of individuals seeking justice. And so we would welcome the position from the states that actually contribute to the rules of the appointment of the justices on the international level, such that do reflect the principles that they have or they endorse and they contribute to the creation on the national level. And that's something that so far we have not seen that much, because we do see that it is very much of a political process. And we do see that the political process implies that individuals that want to be appointed as judges on the European and broadly understood international level first need to overcome the hurdles of the support of the national level. And only then can they adjudicate, however, not without the strings attached. But I think that this is something that we would need to address in a different project altogether. Is that not true, Madalena?
Thank you very much, Carolina. Indeed, I mean, I would say the appointment of judges to both the Court of Justice and European Court of Human Rights could be like a separate different project. But now that you raised this question, Julia, I think there's already literatures and my colleagues from the quite an extensive research on that, and there is a paper published on that. So what I will try to do is in the chat section here to write a little bit more literature reference to literature. But I will also ask Barbara maybe if she could also answer to Julia's question.
Yes, thank you very much, Julia. Thank you, Madalena and Carolina. I'm afraid I do not have much to add to what was said here regarding this work in progress, regarding the standards, but I would like to stress that what we really want to do in our training, transnational training for international arbitrators, I would like to start drawing also parallels, because it is what we are doing today, because arbitrators in many different types of arbitrations are under increased attack regarding, especially in the context of EU law. And we see this most in the context of investment arbitration. And there has been more and more work done regarding the codes of conduct and ethics. And of course, these are more soft law standards, but it depends also on the type of arbitration. At the same time, we can see more and more international arbitration also in the European context. And I think that we cannot ignore the discussion that international arbitrators are also part of the international tribunal system. So I would just like to make this point that we are aiming at defining also those standards through the fact-finding part of the project, and hopefully it can also start a discussion on sharing best practices with international and European judges.
Thank you very much, Barbara. There are two more questions. First, I'll give the floor to Gabor Halmai and then to Marcin Michalak.
Thank you very much for this really very interesting event and presentations. Let me have another question regarding other players as well. So what do you think about the role third national courts can play guaranteeing judicial independence? I'm thinking about the recent cases of the Amsterdam court or the Karlsruhe Landesgericht court regarding the Selmer case. So regarding the European arrest warrant case, partly somehow disregarding ECJ, the two-pronged decision or test of ECJ. Thank you.
Thank you, Gabor. Marcin?
Hello, everyone. It's nice to see you. And as Gabor said, thank you for very interesting speeches. And I would like to just say something on behalf of Professor Koncevich, who unfortunately is not here today, but he asked me to give like a comment from our perspective of the University of Gdańsk. So we just want to say that of course it is important to look at the issue of judicial independence from the perspective as we do it today, but also from a slightly broader perspective. So to look at the judicial process of judges holistically. And as the European Tribunal said, it should be remembered that the judicial independence is a value in the service of the right to effective judicial protection. And that independent tribunal is just one of the requirements linked to this fundamental right to effective remedy. So generally, our point is that it is important that it should be not overlooked, that the problem of judicial independence is an element of the system, and it is worthwhile to look at also from this perspective.
Thank you very much, Marcin. And also, I think your question connects very well to some of the pending cases now before the European Court of Justice. And some of these cases were already pointed out by Carolina as probably the case law and the standards of the European courts are in development. And there are definitely some pending cases with great potential for further developing the standards. But before I give the floor, Barbara, Carolina, are you okay if we collect a bit more questions or do you want to address now? Yes, I've seen more hands, but now I don't see them anymore. Oh, yes, they disappeared. Sorry. So maybe
perhaps that was my hand actually being raised, because in fact, when we were discussing with Barbara the preparation for this webinar, we did address the topic of access to justice, which is one of the points that are being raised. And if we speak about the effect of judicial protection in general, right? So perhaps I could deflect a little bit to Basha, because she was the one that was raising this point, and also she was the one that was pointing to the fact that this is one of the most frequently emerging issues in the jurisprudence referring to the arbitration.
Well, yes, just very briefly, because it's a very big topic. And indeed, we found quite a few cases where arbitration is considered a way of of offering access to justice and access to courts. And again, arbitration hasn't been treated as such. And the whole point also of our today's discussion is to start the dialogue and to say, okay, arbitrators are there also for a reason. And we have to scrutinize the actual role of arbitrators in maintaining the European rule of law. But I would also like to maybe briefly respond also to the role of national courts that Gabor also raised. And just from the perspective of arbitration, because it's also very interesting, and some national laws have proposed to create a bridge between arbitrators and national courts and the European Court of Justice to actually allow arbitrators to have a say on and ask questions on European Union law. So I think that there is also a very interesting role of national courts when it comes to arbitration, not necessarily only in the ordinary justice system, in building this bridge. Carolina?
Well, so replying directly to Gabor, if I can just perhaps bounce back the ball, because I do really think that the whole point lies in the fact that the national courts really press the Court of Justice of the European Union for more and more strict, above all, guidance. And the Court of Justice of the European Union tries to duck. And I think that us as academics, but perhaps also judges, when they try to apply the standard that emerges from this discussion between the national and the Court of Justice, national courts and the Court of Justice of the European Union, we do have a problem of actually identifying this standard, which is to say, well, okay, there is a framework, so there's just frames, you know, within which we all are moving, but we do not have instruments of how to use this framework. And perhaps, if I may just, I see that there's still many participants here gathered. I mean, if I may just call for you, could we perhaps put together a methodology as to what it is that we address when we are evaluating these factual circumstances that are pointed to by both the Court of Justice of the European Union in the context of the European arrest warrant cases, and the applicability of the standard that was emergent from the infringement cases, also mostly against Poland, and also the arbitration cases that Barbara was talking about. How do we apply them to the specific cases? Because ultimately, I do kind of refer back to this original table whereby I'm asking whether there are simple analogies we can draw between the roles and positions of different actors in the field. And as Gabor was actually stating, I mean, we do have many of those actors, and we have many more, and we hope to have many more, contributing to the development of the standards. And the question is, how do we induce them to perhaps put forward the methodology that can be both flexible enough for everybody to use in a specific jurisdiction, and those jurisdictions can vary from accepting arbitrators as quasi-judges and to accepting arbitrators as just simply individuals that fulfill the terms of contracts, which, by the way, I think that the terms of contract actually do lean on a specific standard that needs to be adhered to. It's not that it just comes out of the blue. I mean, and Basia, you've been mentioning a number of the instruments that have been devised in order to determine what it means to be an arbitrator, but still those standards, in addition to those instruments, have been developed by the courts of themselves as well. And there is a certain modality of thinking in terms of, okay, who do we appoint? What is it that this person is expected to do? And how is this person expected to act? And Basia, I'm really sorry, but I'm going to raise the point that we had before when we were preparing this webinar. Namely, the point about the case referring to what was it, the judge, the arbitrator that ended up in his yacht club, whereas his colleagues were actually passing the arbitral award. And the question is, okay, were they actually allowed to do that? To what extent his position and the position of his colleagues was actually stipulated for? I don't think that the contract can actually stipulate for every single one and a behavior of an arbitrator. We actually do expect an arbitrator to maintain the standards of independence and impartiality that is almost akin to that of a judge. Am I wrong?
So if I may also, sorry, Madalena, just 2 cents. Because I also spent some time investigating and writing about civil liability of arbitral institutions, also for misconduct of arbitrators. And of course, the question, there are many theoretical discussions here that are important too. So who are those actors, especially in the arbitration field, and how it affects the performance and potential responsibility, because we also have to give arbitrators freedom to decide on the case, and we have to think about it too. And so we have to treat them as quasi-judges to some extent. And of course, then we have a contract. So there is a hybrid framework for the operation of arbitration. But I was also trying to show in the discussion today that, in fact, when it all is brought down to the judicial level, we really always go back to the core principles, constitutional principles too. And I think that it's important to see and have this dialogue whether we cannot treat arbitration as a little bit distinct system, which offers access to justice and different guarantees, while at the same time, of course, has their own framework for the independence and impartiality. Because just maybe also to give the answer to the question that we wanted to, that we posed for today, there is some overlap, but the overlap brings arbitration back to the ordinary justice system and deprives arbitration and arbitrators from their unique role in the administration of justice. Back to you, Madalena.
Thank you very much, Basia and Carolina. And I know there's so many different questions, so I would like to give the floor to Rita for the last question, and then we'll have the last concluding remarks. Rita?
Thank you so much for the topics in the webinar. It's been really great. Just very quickly on bias, because this is something that I think is particularly interesting. And thank you for Barbara to bringing it in on one of her cases. I just wanted to ask you if you could elaborate a little bit on whether there have been standards elaborated on judicial on bias, but for arbitrators. There is quite a lot on judicial bias, perhaps not enough in regards to courts, but I have to say I'm not very familiar with standards developed in the field of arbitration. So if you have if you could just give us some insight on that. You listed a few of the documents. If you could just give me and overall, I think that's super interesting also to see if there is or not a parallel, and if where do we stand on that from both the arbitration and the judicial fields. Thank you.
Yeah, so basically also we did find also other cases of bias, of course, and it's very prominent also in investor state arbitration. But I would again say that it's always decided and by the judges, at least as in this case, in the context of performance of specific and behavior of specific arbitrator, and also the International Bar Association guidelines. So there are those guidelines with different lists, and I would say that I wouldn't dare to give you like a very close list of standards of principles that we can take into account, because it's always decided on a case-by-case basis, also based on these soft instruments. But again, I hope we will also be able to formulate more concrete principles in the context of our training.
Thank you, Basia. And now for the final conclusions, I would like you to ask if there is anything like major conclusions to conclude this very rich webinar. Carolina, do you want to add anything to what Basia has said?
Actually, yes. I would like to point your attention to one of the cases that are actually figured in the database of TRIIAL that focuses on perhaps not bias, but the separate opinions of one of the judges in the aftermath of the Court of Justice cases concerning Poland. So in fact, those cases, and I invite you to kind of dig into the database so that perhaps without a link, you'll be inclined to have a look at it. It's just to see how the bias, in fact, isn't addressed by enabling the separate opinion. I think that this is an important thing. And secondly, I do invite you to perhaps contact us, both Madalena and myself, and perhaps Madalena can forward this to me if you have any thoughts about really this examination of the factual examination of the standard of judicial independence in concrete cases in terms of how we can address it. And finally, I will leave some floor to Basia to say, but maybe Basia can repeat after me so that you do not forget. On the 18th of March, we do convene again for the webinar on the judging the judges. So this time we're taking as a focus point the judicial accountability. And we invite you to participate in it, and yeah, be ready to address those very, very difficult questions. Basia, over to you.
Yes, I think you summarized it very nicely, Carolina. And indeed, I will be very curious in this next upcoming webinar. And I would just like to again stress that we included also arbitration in this project for some reason. And also, if any of you have any questions or suggestions regarding the role of arbitration in the project or in the discussion on the standard of independence and impartiality and any other topics, I'm all ears. So feel free to drop me a line, and because I think we really have to start treating arbitrators and judges equally and be able to allow the discussion where we learn from one system and another.
Thank you both for your concluding remarks. I would like to just add that indeed we have the next webinar on the 18th of March, and that will address judicial accountability. And I think this will also be an opportunity to go more in depth into the facts, as Carolina was saying, because what is the added value of the now pending cases before the European Court of Justice? These are cases that come from Romania, and the advantages of coming from these countries is that the court is forced to go more into the facts, to go more precise with the standards, because now there is a connection, clear connection with the scope of EU law under the mechanism for verification and cooperation. So we'll see whether the court will going to proceed or not. Definitely we have an opinion from the Advocate General, and we will discuss that during the 18th of March together with other topics. And Basha and Carolina have not yet mentioned that, but of course this series does not stop here. We will have a series of transnational trainings that is open for applications. We will post the call for selection of participants next week. And let me say that there will be 4 transnational trainings on the 5 main themes of the project, that is on mutual trust, that will be organized in May by the University of Florence. There will be a topic on judicial appointments and judicial self-government, and that transnational training will be organized by Carolina at the University of Maastricht. Then there will be the transnational training organized by Barbara in Hague. Of course, I'm saying the towns, but they don't matter because we will all do in online format. So you can apply wherever you are. And then the last transnational training, which will be on judicial accountability, and it will be organized on the 18th of June. But I will make sure that all the participants will receive information with these dates and future events. So just in conclusion, I have to thank you for being so patient and staying with us in such a high number, although we were supposed to finish 20 minutes ago. So thank you very much for all your questions. Of course, you can, if you have further questions or you want to go back and remember some of the issues that were discussed, you will find the webinar recorded on the webpage of TRIIAL project in the Center for Judicial Cooperation. So once again, thank you, Carolina, thank you, Barbara, and thank you to all the participants. And we look forward to see you on the 18th of March. Have a nice evening. Take care. Bye-bye.